Welcome to U.S. Policy Brief, where we navigate the complex and ever-changing landscape of American immigration law, enforcement trends, and federal policy adjustments. Today is March 16th, and we have a significant amount of ground to cover regarding the current state of the U.S. immigration system. In this broadcast, we are going to dissect the latest news coming out of the Department of Homeland Security and the State Department, specifically focusing on enforcement actions, funding debates, and the ongoing pauses affecting nationals from specific countries. We will also transition into a detailed analysis of common questions regarding family-based petitions, asylum procedures, and deportation defense. Our goal is to provide you with a comprehensive understanding of these mechanisms so you can navigate your own immigration journey with clarity and confidence. While the political climate often suggests that immigration processes have stalled or are solely focused on enforcement, it is crucial to understand that the administrative system is still functioning, and approvals are still being issued for those who meet the strict eligibility requirements. We will explore what this looks like in practice, examining successful case studies that prove the system works, even amidst aggressive policy shifts. Let us begin by addressing the latest developments in immigration enforcement news, specifically regarding the expansion of detention capabilities. There are emerging reports indicating that the administration is planning to significantly expand family detention centers with a specific focus on a new facility at the Alexandria International Airport in Louisiana. Louisiana has increasingly become a central hub for deportation flights and detention operations in the United States. The administration is reportedly planning to create a short-term facility designed to hold families, which, in the context of immigration enforcement, almost exclusively refers to women and children. This facility is expected to be operational within the next 60 to 90 days. The operational model for this facility suggests that it will be used to house individuals for short durations, likely 3 to 5 days, in converted military barracks located near the runway used for deportation flights. The Department of Homeland Security has framed this as a processing center for individuals who have selected voluntary departure, suggesting that it is a pathway for those who wish to resolve their cases by leaving the United States. However, policy analysts and advocates argue that the conditions within detention often pressure individuals into signing voluntary departure paperwork simply to escape confinement, rather than as a true exercise of free will. This development highlights a continued aggressive stance on enforcement and the physical expansion of the deportation infrastructure in the southern states. If you or a loved one are facing detention, particularly in states like Louisiana, Texas, or Mississippi, where policies are notably strict, it is imperative to act immediately with legal counsel to explore options such as habeas corpus petitions or bond motions. In the realm of agency funding and operations, there is an ongoing debate in Congress regarding the budget for the Department of Homeland Security. Lawmakers are scrutinizing the funding levels requested by the agency, citing concerns over recent operational conduct and policy implementation. This budgetary friction has real-world consequences, as seen recently with the temporary shutdown of the Global Entry Program, which has since been reactivated. These funding battles are critical to watch because they often dictate the resources available for both enforcement and benefit adjudication. Furthermore, the Supreme Court is currently weighing in on the issue of temporary protected status for Haitian nationals, a case that the administration brought to the court's emergency docket. This decision will have profound implications for the stability of thousands of individuals currently protected under TPS. Additionally, privacy advocates are raising alarms regarding a new DHS initiative to access sensitive federal databases managed by the Department of Health and Human Services. These databases, which include the Federal Parent Locator Service and the National Directory of New Hires, contain employment and child support data for millions of people. The intent behind seeking this access is to enhance the government's ability to track individuals, but it raises significant legal questions regarding privacy laws and the potential violation of federal statutes protecting this sensitive data. This move signifies a shift toward a data-driven enforcement model where the government leverages information across various agencies to identify and locate non-citizens. Despite these aggressive enforcement measures and policy pauses affecting nationals from dozens of countries, it is vital to recognize that the legal immigration system continues to produce results for eligible applicants. To illustrate this, we can look at a recent case involving a Jamaican national who successfully adjusted her status to a permanent resident. This individual entered the United States lawfully in 2013 on a visitor visa and subsequently overstayed. However, she had no criminal record and no arrest history. Her daughter, who recently naturalized as a U.S. citizen, filed a petition on her behalf. Because the mother entered lawfully and was being petitioned by an immediate relative, a U.S. citizen child over the age of 21, the overstay was forgiven under current immigration law. The case was filed in November and the green card was approved by February, a process taking only 3 months. This example serves as a powerful reminder that despite the noise in the news and the very real hurdles facing many applicants, the statutory framework for adjustment of status remains intact and functional for those who qualify. It underscores the importance of not letting fear or rumors deter you from verifying your eligibility and submitting an application if a pathway exists. We will now transition into a deep dive into specific immigration scenarios and questions that reflect the complexities many of you are facing. A frequent area of inquiry involves the military parole in place program. This is a discretionary benefit that allows certain undocumented family members of active duty members or veterans of the U.S. Armed Forces to remain in the United States and adjust their status without having to leave the country for consular processing. The specific eligibility requirements and the documentation needed, such as the service member's contract or proof of service, are rigorous. It is dangerous to rely on a generic checklist because the requirements can vary based on the specific branch of service and the applicant's history. Generally, however, this policy remains one of the few ways to cure an unlawful entry without triggering the 3 or 10-year bars associated with leaving the U.S., making it a critical option for military families. Another common concern relates to visa overstays and the timing of seeking legal help. Many individuals worry that once their visa expires, their opportunity to fix their status has vanished. As illustrated by the success story mentioned earlier, an expired visa does not automatically disqualify someone from adjusting their status, provided they have a qualifying petitioner, such as a U.S. citizen spouse or adult child. The critical factor is usually the manner of entry. A lawful entry with inspection is a prerequisite for adjustment of status within the U.S. for most family-based cases. However, if the petitioner is a permanent resident rather than a citizen, or if the applicant is seeking an employment-based green card, an overstay can be a fatal bar to adjusting status within the U.S., often requiring the applicant to leave the country and seek a waiver. Therefore, while expiration is not the end of the road, it severely limits the available pathways and necessitates immediate strategic planning. Regarding processing times, particularly for employment authorization documents, we are seeing significant variability. While some marriage-based cases are seeing work permits issued within 3 months, other categories, particularly humanitarian cases like VAWA or asylum, are experiencing delays. If an applicant has completed biometrics but has been waiting months for a work permit, it is often a reflection of the specific backlog associated with that case category rather than an error in the file. However, inquiries should be made if the processing time exceeds the published norms for that specific service center. It is also important to address the vetting process for those entering the United States. Whether entering on an immigrant visa or a tourist visa, the U.S. government conducts extensive background checks involving international databases to identify criminal records in the applicant's home country. The DS-260 and DS-160 forms specifically ask about criminal history, and consular officers have access to data-sharing agreements with many nations. A clean record in the U.S. does not negate a criminal record abroad, and failure to disclose such information can lead to a permanent bar for fraud or material misrepresentation. There is also considerable confusion regarding the various bans or pauses on visa issuance currently affecting nationals from specific countries. For example, there is a policy impacting the issuance of immigrant visas for nationals of roughly 75 countries, and a separate adjudication pause at USCIS, affecting nationals of about 39 countries. Despite these pauses, the advice from policy experts is generally to continue with the application process. For instance, if you are a U.S. citizen planning to marry a national from a country affected by a visa issuance pause, you can still file the I-130 petition. USCIS is legally obligated to process the I-130 to establish the validity of the relationship. The pause typically affects the final stage of visa issuance or the final adjudication of the green card. By filing now, you secure a priority date and get the case into the system. If the pause is still in effect by the time the case reaches the final stage, legal avenues such as participating in group litigation or federal lawsuits may be necessary to force the government to adjudicate the case. Filing the initial petition is the necessary first step to having standing to challenge any delays later. We must also clarify the relationship between work permits and deportation. There is a dangerous misconception that holding a valid employment authorization document protects an individual from removal proceedings. This is not true. A work permit is simply an administrative benefit that allows you to work while a primary application is pending, or because you hold a temporary status. It does not grant you lawful immigration status, nor does it shield you from enforcement if an immigration judge issues a removal order or if ICE targets you for other reasons. The current administration has shown a willingness to detain and deport individuals, even if they have pending applications and valid work permits, particularly if there are other negative factors in the case. This is why reliance solely on a work permit without a strategy for permanent status is risky. For lawful permanent residents, questions often arise regarding when they can apply for citizenship. The general rule is 5 years of continuous residence. However, there is a special provision for those married to U.S. citizens. If you obtained your green card through marriage and you remain married to and living in marital union with that same U.S. citizen spouse, you may apply for naturalization after 3 years. This marital union requirement is strict. If you are separated or no longer living together, you do not qualify for the 3-year rule and must wait for the full 5 years. Furthermore, if you are a conditional resident, meaning you have a 2-year green card, and you have filed the I-751 petition to remove conditions, you can still file for naturalization once you hit the 3-year mark, even if the I-751 is still pending. USCIS will typically adjudicate the I-751 and the N-400 naturalization application at the same interview. This strategy can actually force a decision on a stalled I-751 petition. Travel is another area fraught with anxiety. If you are a permanent resident and your green card has expired, but you have filed for a renewal, the receipt notice, Form I-797, often acts as an automatic extension of the card's validity, typically for 24 or 48 months. You can travel with your expired card and this letter. However, if you do not have the letter, or if it has expired, you must obtain an addit stamp, also known as an I-5551 stamp, in your passport from a local USCIS field office before traveling. Leaving the U.S. without valid proof of permanent residence can result in significant difficulties re-entering the country or even having the airline refuse to board you. We are also monitoring the adjudication pause affecting nationals of approximately 39 countries, including Nigeria. We have seen instances where individuals have attended their adjustment of status interviews, only to be told that a decision cannot be made due to this policy hold. If you find yourself in this limbo, where the interview is complete but no decision is issued for months or years, the administrative delay can be challenged. This is often done through a writ of mandamus lawsuit in federal court, which compels the government to do its job and issue a decision. While you cannot force a yes, you can force a response. This pause is also affecting U.S. citizens who were born in these specific countries. We have seen cases where a U.S. citizen petitioner, born in a flagged country, faces delays in petitioning for a spouse who is not from that country. This suggests the policy is being applied broadly based on country of birth rather than just the beneficiary's nationality, which raises serious equal protection concerns regarding temporary protected status, TPS. Specifically for countries like Ethiopia, it is crucial to stay updated on the specific designation periods. If an individual misses the re-registration window, they may lose their status and their work authorization. While late filing is sometimes permitted for good cause, it is a discretionary hurdle. Using an expired TPS work permit is not advisable unless there is an automatic extension notice published in the Federal Register. Always consult the specific Federal Register notice for your country's TPS designation to determine the validity of your documents. On the topic of asylum, we often hear from individuals who have pending asylum applications but subsequently marry a U.S. citizen. They face the decision of whether to withdraw the asylum claim to pursue the marriage-based green card. This is a delicate strategic decision. If the asylum claim was weak or frivolous, withdrawing it can be the right move, but it must be done carefully. For some, withdrawing an asylum application can trigger a referral to ICE if the person has no other underlying lawful status. The best practice is usually to proceed with the marriage-based petition and only withdraw the asylum claim once the green card is approved or at the adjustment interview, ensuring there is no gap in protection. Furthermore, if the asylum case is already in immigration court, only the judge can adjudicate the green card application, unless the judge terminates proceedings to allow USCIS to do it. This jurisdictional split adds a layer of complexity that requires professional legal navigation. For those who entered the United States without inspection, meaning they crossed the border without meeting a visa officer, the path to a green card is more difficult. Even if such a person marries a U.S. citizen, they generally cannot adjust status inside the U.S. because they lack a lawful admission. The standard process involves filing the I-130 petition and, once approved, applying for an I-601A provisional unlawful presence waiver. This waiver asks the government to forgive the illegal entry based on extreme hardship to the U.S. citizen's spouse. If the waiver is approved, the applicant must then travel to their home country for a consular interview to receive the immigrant visa. This process carries the risk of leaving the country, and the current processing times for these waivers can be several years. The only major exception is for immediate relatives of military members, who can use the parole-in-place mechanism mentioned earlier to fix their entry record without leaving the U.S. In terms of legislative updates, the question of comprehensive immigration reform remains a perennial topic. Many ask if there is hope for DACA recipients or a general amnesty. The political reality is that a congressional solution is unlikely in the current polarized environment. However, there is always the possibility of executive action. History suggests that sometimes, paradoxically, strict administrations may negotiate targeted reform as part of a broader enforcement package. There is speculation that the White House could use executive orders to provide relief to specific groups, such as long-term residents or DACA holders, perhaps in exchange for tighter border funding. While we cannot bank on this, the landscape is fluid. In the meantime, relying on existing statutes like the 245I grandfathering clause, which allows certain people with old petitions filed before April 30, 2001, to adjust status despite unlawful entries, remains a vital, albeit narrowing, avenue for relief. We also see questions regarding the intersection of family law and immigration, particularly regarding child support. A U.S. citizen who owes back child support is not barred from petitioning for a foreign spouse. The immigration forms do not ask about child support arrears as a disqualifying factor for the petitioner. However, the financial sponsorship requirement, Form I-864, is rigorous. If the petitioner's income is garnished or insufficient due to other debts, they may fail to meet the poverty guidelines required to sponsor an immigrant. In such cases, a joint sponsor, a distinct individual who meets the financial criteria, would be necessary to ensure the beneficiary does not become a public charge. Finally, a word on deportation defense for those who already hold green cards. It is a sobering reality that permanent residency is not truly permanent until one becomes a U.S. citizen. Green card holders can be, and frequently are, placed in removal proceedings for committing certain crimes, particularly aggravated felonies or crimes involving moral turpitude. We have represented former green card holders who were stripped of their status and ordered deported. This highlights the importance of naturalizing as soon as eligible. Citizenship provides the ultimate protection against deportation. If you have a green card and a criminal record, you should consult an immigration attorney before applying for citizenship or traveling outside the U.S., as these actions can trigger a review of your file and potentially lead to removal proceedings. As we conclude this briefing, remember that while the news often focuses on the macro-level political battles, your immigration journey is determined by the specific facts of your case and the application of current law. Whether you are dealing with a delayed visa, a complex marriage petition, or the threat of removal, the system, while slow and often harsh, does function for those who navigate it correctly. At U.S. Policy Brief, we are dedicated to bringing you the analysis you need to understand these shifts. We encourage you to stay engaged, educate yourself on the requirements, and seek professional guidance when the path becomes unclear. The landscape of U.S. immigration is one of hurdles and opportunities. Knowing which is the key to securing your future in the United States. Thank you for tuning in to this extensive policy review. We will continue to monitor the courts, Congress, and the agencies to bring you the latest updates as they happen. Stay informed and stay prepared.